Good afternoon, everyone. My name is Sarah Ochwada. I am a pioneering practitioner at the frontier of sports, entertainment, and fashion law, with a practice spanning over 13 years in sports legislation, arbitration, lecturing, and litigation. I currently serve as the vice chair of the FIFA Football Tribunal Player Status Chamber, and I am involved in shaping national and sports policies in safeguarding. So I can see some of our attendees are non-lawyers. For example, Ms. Quinta Odongo, who does some incredible work in sports management in Kenya. Karibu sana. And I'll be presenting a little bit differently than my fellow panelists. I don't have any slides, but I would like for you to listen actively without relying so much on what's on your screen. Okay? So today I would like us to focus on how together, whether you're a legal practitioner or not, we can create frameworks that protect the dignity of the most vulnerable classes of people working within sports. And I want to begin by sharing a secret and end by giving you a challenge. So what's my secret? Well, the secret isn't mine per se. It's a secret within the realm of sports that people rarely report to institutions, but they report to people they trust. So within my own experience, complaints have been brought to me by family members, a friend, a colleague who is connected to a victim of a breach of trust. And majority of these complaints I've received are raised by journalists, and not the kind of journalists who do investigative work or investigative journalism, but the journalists who are trained to work on the field every day, creating reports for the daily news or recording scores for their sports desks. And why do people trust field journalists more than they trust officers within their own sports institutions? It's because of a system of fear and silence. Sports officials are perceived as being too valuable to be reported, or rather they are more valuable than the sports person or the official who's working within the ecosystem. So sports people, athletes seek solace or sympathy from someone who is an insider without really being so much of an insider, but who is an outsider enough of their ecosystem where they can be trusted with the information and not suffer from retaliation. So where do we go from here? We can start with understanding the sporting ecosystem. And the sports ecosystem has two kinds of personalities or two kinds of people. You have regulators and you have operators, as my colleagues have mentioned. And very often, when we're dealing with regulators and operators, we have a network of power imbalance, because both the regulators and the operators want to control two things. They want to control access and they want to control resources. So let's start from identifying who are these regulators, who are the operators, and then we'll dive into how these two groups act in relation to access and resources within sport, and then how access and resources also leads to safeguarding mechanisms. Okay? I hope I'm not going too quickly. If I am, just give me a heads up, Kyron. So regulators are the ones who build the sports systems that we all know and enjoy. They determine how people function within these sports systems. So a good example is international sports federations such as FIFA and their member associations such as FKF or FUFA from Uganda, right? Or you could have a regulator who is a multi-sports organization such as the International Olympic Committee and its affiliates, which are the National Olympic Committees of every nation in the world. Or you could have a regulator who's in charge of certain disciplinary mechanisms, such as anti-doping. So you have an anti-doping body such as the World Anti-Doping Agency, or WADA, and its national anti-doping organizations worldwide. So those are the regulators within the ecosystem. And then the operators are the ones who act at various levels, who ensure that this machinery of sports keeps running. Okay, so you have sports administrators or executives. You have athlete support personnel such as coaches, trainers, scouts, agents, And finally, at the bottom of that pyramid, you have athletes themselves. So how do these regulators and operators behave in relation to access and resources? Access is a dual capacity highway. You're either controlling access to opportunities or you are controlling access to an asset. So the greatest opportunity for an athlete in sports is participation in competition. Athletes are seeking this golden ticket. Access to competitions will help them earn a living. And many times the person between an athlete and that golden ticket is either an administrator or an athlete support personnel. On the flip side, the greatest asset for a regulator is an athlete. Without talented athletes, there will be no competition. So regulators leverage access to competitions in order to unlock money from sponsors. But the people controlling access to the talent are administrators and athlete support personnel. So this ecosystem is fertile ground for abuse and exploitation. So I'm going to tell you about some of the abuses in the sporting ecosystem. I will name them and briefly explain what they are. And then towards the end or towards the panel discussion, I can give you actual examples of some of the situations that I've personally dealt with, which deal with these kind of exploitative systems. Okay, so the first kind of abuse within the sporting ecosystem is administrative abuses of power. And these happen mostly during player registration or team selection, okay, because you're controlling access to competition. So what you'll have during player registration or team selection is age manipulation. Either you'll be signed up as older or younger than you are, or you'll have retaliation for insubordination. Suppose you reported someone or an official for doing something wrong, they will retaliate by saying, I will not put you on this team. Or, as one of my colleagues has mentioned, Timothy, there is compulsory gender testing. And this is an administrative abuse of power if you take people out of training or if you take them out of their schooling system and you tell them, we must force you to take this gender testing, otherwise you will not participate in sports. And another abuse of power is sports trafficking. You move individuals from one location to another for purposes of involving them in some sort of competition. You do it either through coercion or force. And the difference between coercion and force is that coercion can be done through threats or false promises. And a lot of times people fall for false promises. You'll get a lot of money, we'll take care of your parents, we'll buy you land, we'll put you through schooling and such. So that's the first kind of abuse within the sporting ecosystem, administrative abuse of power. The second form of abuse is fiduciary abuse. Okay? A fiduciary is someone who is put in a position of duty to help you. For example, your agent or your manager or your lawyer. But sometimes a fiduciary abuse comes about when you have self-dealing tactics, where the agent, the manager, or the lawyer puts themselves in a position to benefit at the expense of the athlete who you owe a fiduciary duty to. So some of the fiduciary abuses within the sports ecosystem include illegal contracting of minors, whereabouts failures, and let me explain a little bit where illegal contracting of minors and whereabouts failures come into play. So you could be an agent or a manager or a lawyer, and in order for you to contract a minor, you need to have the consent of the parents. But the way you go about getting that consent of the parent or the legal guardian is what is coming into question, because a lot of these parents sign over control of their minors so that these minors are contracted to professional or semi-professional competitions. And a lot of times they rarely see any fruits of the labor of the minors. And where does whereabouts failures come in? A lot of our athletes, especially those who come from rural areas, are either literate or semi-literate. So they leave the filing of their anti-doping whereabouts to their agents or managers. And sometimes whenever there's a disagreement or a contractual issue, these agents and managers will say, we're going to mess up your whereabout filings so that you will get suspended for 2 years and you will no longer be able to participate in sports unless you stick to us and extend your contract. So that's some of the fiduciary abuses that go on in sports. The third kind of fiduciary abuse is unjust enrichment, and it's different from a fiduciary abuse. The third kind of abuse within sport is unjust enrichment, and it's different from fiduciary abuse in that fiduciary abuse, you have someone who is has a professional duty towards you. But unjust enrichment occurs when someone who does not necessarily have a professional duty towards you unfairly benefits at your expense without earning it or providing compensation for it. So this is particularly rife amongst guardians of minors, spouses of athletes, or even other family members like siblings who fraudulently obtain money from athletes who have just been paid, or they transfer properties to themselves, even though that property belongs to the athlete, who is their wife, their brother, or whatever the case may be. The fourth type of abuse I'll speak about, and it's kind of connected to the next two, or allow me to just list them: the sexual abuse, sexual exploitation, and sexual harassment. And there are three very distinctive types of abuses. So sexual abuse occurs when there's actual or threatened physical or psychological intrusion of a sexual nature. It can either be by force or by coercion. It has to be actual or threatened to your physical body or to your psychological mind of a sexual nature, either by force or by coercion. It's different from sexual exploitation, which is an actual or attempted abuse of a sexual nature by a person in authority or in a position of trust against a person who is in a position of vulnerability in exchange for access to opportunity. So, for example, you have a coach or a manager who says, we need you to do this sexual favor for us in order for you to gain access to competition or in order for you to gain access to the next team selection. A very now famous case of sexual exploitation and sexual abuse. There's been the cases with the US gymnastics team, where Simone Biles and her teammates came together to report the sexual abuses that had been going on against them. And also the case which was heard and determined by the FIFA disciplinary about the ex-under-17 coach from Gabon. Then you have sexual harassment. And sexual harassment is basically any unwelcome sexual advances, gestures, or requests for a sexual favor that may cause offense or humiliation. If your idea is to simply goad at someone for the sake of humiliating them or causing them offense, that would be sexual harassment. And all these type of abuses are dealt with differently in sport. So let me just list them again. The kind of abuses within the sports ecosystem: administrative abuses of power, fiduciary abuses by lawyers, agents, and managers, unjust enrichment by guardians of minors and spouses of athletes, sexual abuse, sexual exploitation, and sexual harassment. So how do we create guardrails within safeguarding frameworks to ensure effective protection within sports? Because what safeguarding is essentially is trust building and intervention. And right now, the problem is a lot of our safeguarding tools provide frameworks which assume that the offense has to happen before we step in. So my challenge is, can we flip it so that we don't have a perfect system which takes care of an offense after it has happened, but have a livable framework which will help someone before the offense takes place, or if someone feels like something is wrong or off but doesn't have the vocabulary to explain that this is wrong and off, but I know something has to be done. So what do you do if you have that kind of feeling, or you need to seek help if you suspect something is off? Some of our frameworks need to have, or rather, our frameworks need to track three things. They need to be understandable, they need to be accessible, and finally, they have to be emotionally safe, because you're dealing with a human-to-human relationship. So what do I mean by this? A framework being understandable. It should be written or available either in plain language or in a medium that a vulnerable person understands. For example, if it's written, it has to be plain English or plain Kiswahili or plain whatever language you are speaking in your nation. But if you are a person with disability, it has to be available in a medium that you understand. A blind person might be able to access audio, or might be able to access Braille. A deaf person will hopefully be able to read, but you can make it available in sign language if you're going to have someone who will digitize it or record it on a camera. But if you're literate or semi-literate, what kind of medium are we going to make this information available in? Do we just do it in form of a podcast, a short note, an audio? What do we do? So the rules have to be understandable to the vulnerable person who needs to benefit from it. The rules also have to be accessible, meaning they have to be visible and not hidden. So a lot of these forms that we have come up with, yes, but you find like the third page after the fifth click after answering a few questions, so you find the report form. It's not as easily available as, let's say, access to ticketing information for the next match of Chan. Right? So this is something that we need to work on. How can we make our interventions accessible? And lastly, our interventions or the policies have to be emotionally safe. They have to promote trust building, because silence is dangerous. But speaking up shouldn't feel like a personal risk, which is why I mentioned a lot of times athletes will more likely express themselves with a journalist who is around them day to day because they know them. And in many occasions, even those journalists see for themselves or witness the kind of atrocities that are going on day to day with these sports people. So they feel like perhaps these daily journalists are a safer space for me to explain myself, rather than going through the system of safeguarding chaperones, officers, officials who have been given by the federations, and who, by the way, some of are offenders, but who are still working within those federations. Now, everything I've told you should ideally work within the private law realm that sports operates in. But sports doesn't exist in a vacuum. It operates within the context of social contracts and nationhood. So beyond disciplinary measures, we should also explore public law mechanisms to bolster safeguarding efforts within sports. What do I mean by this? We need integration or complementarity between sports disciplinary systems and criminal prosecutions. For example, sexual offenses. Kenya has a very robust Sexual Offences Act, and it also recently digitized the Sexual Offenders Registry. But there's no link between the sports ecosystem and the criminal prosecution system and the judiciary system of Sexual Offenders Registry. The other thing we should do is have reporting of fraudulent acts to financial institutions such as banks and land registries to safeguard the finances of those within the sports ecosystem. We should also have a system of issuing protection orders as soon as possible or within at least 3 hours of issuing a complaint. So what does a protection order do? It ensures that whoever has been suspected of offending a particular victim will not have access to them for a period of time until or unless investigations have been done. So that means within the legal system, you are not allowed to approach this person for however long. And then that will follow up with or be complemented with whatever disciplinary processes that the offender will have to go through within sports. And then lastly, we should have better information sharing networks between the operators. For example, if you have an offender who is working within athletics and then athletics bans them from athletics for life, that does not stop that offender from joining volleyball and doing the very same thing. So information sharing networks between the different disciplines are important, but also information sharing between law enforcement authorities as well. So let me leave you with that for now. Just let you know that safeguarding is no longer a luxury and it shouldn't be a privilege. It should be a professional standard and a human right. So I'll be open to questions and explaining anything else that you might have, in case you're curious about the subject matter. Thank you.